This video is all about how independent and neutral the judiciary is in the United Kingdom. By independent, we mean the principle that those in the judiciary should be free from political control. This allows judges to do the right thing, free from fear of consequences. And by neutrality, we mean that judges should operate impartially, i.e. without any personal bias. Judges in the UK are expected to operate with a high level of independence and to dispense justice with a degree of neutrality. Absence of independence will threaten neutrality because if judges are subject to external control, their impartiality may be compromised. However, independence does not necessarily guarantee neutrality, as judges may allow personal views to influence their decisions. There are 6 pillars for judicial independence and 3 factors for judicial neutrality that make sure judges in the UK are your sexy pals. First, security of tenure for judges. Judges have an open-ending term but must retire by the age of 75. Second, experience of senior judges. Most senior judges have served a lengthy apprenticeship as barristers. Their professional pride in their position means they would rarely be swayed by outside political pressures. Judges are also subject to contempt of court. These subjudicial rules prevent any individuals from speaking publicly outside the courtroom during legal proceedings. Judges are given a guaranteed salary by an independent fund called the Consolidated Fund. Salaries of judges cannot be altered by politicians. Therefore, judges are free from financial pressures. Since the introduction of the 2005 Constitutional Reform Act, there has been a separation of powers. The downgrading of the post of Lord Chancellor and the creation of a new UK Supreme Court means that the judiciary is no longer subject to such intense political pressures. And finally, in the Constitutional Reform Act, the creation of an independent appointment system, the Judicial Appointment System, or JAC, has led to a greater transparency and less politicisation in the process of judicial appointments. Threats do remain to the independence of the judiciary. For example, the government retains control of the judiciary through the Justice Ministry. The Prime Minister also has a power of veto over JAC appointments. And finally, outside pressure from the media and from politicians may influence court cases. However, the recent Abogada case shows that in the UK, the judiciary are largely independent. In simple terms, of course, it is impossible to guarantee judicial neutrality. Judges are human after all, and they will inevitably bring some degree of personal bias to their work. However, judges argue that neutrality is guaranteed by 3 principles, PAL. P stands for political neutrality. First, judges are not supposed to campaign on behalf of a political party or pressure group, or maintain public political affiliation. A is for anonymity. Judges have traditionally operated away from the public eye and maintained public anonymity. L is for legal justification. Every decision made by a judge must have a legal justification and be rooted in law. However, some checks do remain on judicial neutrality. First, elitism. 11 of 12 Supreme Court judges were educated at Oxford or Cambridge. Second, ethnicity. No ethnic minorities are represented by the Supreme Court. And finally, gender. 1 woman is represented on the UK Supreme Court, and there are no women as heads of the UK appeals courts. Therefore, there is an argument that the judiciary will be inherently biased in terms of gender, ethnicity, and socio-economic background. However, with the introduction of the Human Rights Act 1998 and the Constitutional Reform Act 2005, the hard evidence has shown that the judiciary is more able to support minority and individual rights and criticise government for encroaching on civil liberties. Thanks for watching.